Hello, dear friends. This is Guyana Consulting and Legal Practice. Today, I would like to share with you the review of three legal concepts which may be of interest to all of us who are interested in the Latin American legal context and specifically the Chilean legal system. So let us check three interesting concepts which may help us to introduce ourselves in this fascinating world. Um, One of the first concepts we see is abuso de derecho, which could be translated as the abuse of rights. Rights must be exercised in conformity with the principles of good faith. The law does not protect the abusive or the antisocial use of a right. Abuse of law is to rely on a legal provision, on a law closing the eyes to the reality of the facts, to the course of the word, and to act as if only that provision were a reality, even though trailing off the roads of justice and of equity. So here in this concept of abuse of rights, abuso de derecho, what it does mean is to exercise what normally could be considered a legitimate right in an illegitimate way. So we have some right which is uh, guaranteed by law in some way, but the use of this right is such that the effects of it are just as it's put here, trailing off the roads of justice and equity. So to an illegitimate objective. Um, as it's well put as well here, is an antisocial use of a right. So, for example, in order to better illustrate this, we have Article 56 from our water statute, the water statute from the Chilean law, el Código de Aguas. It says that anyone could dig a well in his or her own property in order to have it for domestic use. But even if it results in the detriment of the water of another well, but if no utility is reported, or such utility would be in a way lesser than the damage caused by the action, then there is the obligation of closing the well. Here we have a clear example on what you call abuse of right, abuso de derecho, and how does the law engage with it. We have accession. Accession or accession. Here we have the ownership of a thing by accession includes the ownership of everything that it produces or is united with it, either naturally or artificially. This is from the Louisiana Civil Code. And what it means is that the owner of a thing is also the owner of whatever such thing may produce. For example, if I have a tree, I am the owner of the fruit of such tree. If I have a cow, I am the owner of the milk it produces. I am the owner of the offspring it may give, and so on. In Chilean law, we have the example of Article 643, which says that accession is the way of acquiring a thing by which the owner of a thing becomes the owner of whatever it produces or whatever joins to it. The products or the produces of these things are called the fruits, which may be natural fruits or civil fruits. Natural fruits are those things I've already mentioned in the previous example, such as the apples from a tree, sorry, and the offspring of a cow or the milk of a cow. That might be good examples of natural fruits. Whereas on civilian fruits, when we talk about civilian fruits, we are referring to a more in a more pecuniary sense. They are more pecuniary fruits, refer to some sort of profit or rent. So those are the fruits. And a third example I would like to review is acción revocatoria or Pauliana, which is the revocatory action or Paulian action, by which an obligee has the right to annul an act of the obligor or the result of a failure to act of the obligor made or effected after the right of the obligee arose that causes or increases the obligor's insolvency. The revocatory or Paulian action is an institution derived from Roman law, and it's the civil law analog to the common law suit or to set aside a fraudulent conveyance, also taken from the Louisiana Civil Code. So, just to trying to put it into vernacular, this action is the action that creditors have in order to annul certain acts, certain contracts, certain conventions by debtors that may try to, in some way, act in detriment of the right of such creditors um, uh, by making itself insolvent. So if we go to the example we have in our own Chilean Civil Code, Article 2468, it says that regarding those acts, those contracts, those conventions executed before the granting of goods or the opening of a concurrence, the following rules will be observed. And then we have in number one, we have that the creditors would have the right to annul onerous contracts and the guarantees that the debtor would have granted in detriment of their own right, doing this in bad faith, um, and being in bad faith the grantor and the acquiring party, knowing both or having both the knowledge of the bad state the of the of the businesses of the former. So in this way, if in a way it's this is the what in common law it's called the fraudulent conveyance. So whenever this happens, the creditors have the right to annul such acts from the debtor in order to protect their own interest, to protect their own rights in this case. So these are the three concepts that we have explained in this short video. I think it serves as a good introduction for those who are interested in Chilean law in the Latin American context. I think it would be great to have further sessions, further explanations. If there is anything that might interest you, please check out this channel. Please write us in the comments. Please subscribe to us. And I will be glad to explore different concepts. This is just a test video. We are starting with this channel right now, and I will be very glad to review different concepts, to translate for you the reality of the Chilean legal system into English for all of you who are interested in this context, who are interested in Chilean law, in Chile as a country, as the institutions of this country, people who are interested in investing in Chile, people who are contemplating the possibility of living here in Chile. I think there is plenty of topics that we may check together. So please subscribe to this channel. Please write in the comments what other subject would you like to review with me, and that's it. Uh, Oyana Consulting and Legal Practice. If you have any doubts, write to me to the email, which is carlos dot ignacio 3 at gmail.com, or follow us on YouTube and Instagram, Rihanna Consulting and Legal Practice. This is not only a YouTube channel, but also I am a current practicing attorney, and I would be very glad to help you with any legal inquiries, with any legal problems you may have, to actually represent you if you need such services. Don't hesitate to consult me on anything you would like. So that's it, guys. Thank you very much. Take care and see you next time.